If you have a great job, keep scrolling. This post is only for people with sucky jobs who are struggling and unhappy. Now, here's what's important to know. There is no law in the United States or in any state that bans or prohibits sucky jobs. There is no law in the United States that prohibits bullying, believe it or not, in the workplace, unless the bullying is discriminatory. But general bullying is perfectly legal, just like a general hostile work environment is perfectly legal. There is no law against sucky bosses, tyrants, toxicity. People say I'm in a toxic work environment. Toxicity is perfectly legal unless it's discriminatory. So here's what you have, and it is mostly discriminatory. But if you can't identify why it's different and sucky for you, that means you should just really look for another job or put your head down and deal with it, because there's no specific mechanism to help you with sucky ass jobs that aren't discriminatory. Now, if you're a woman, for example, there are many categories where the suckiness may be attributed to your unhappiness and failure to pay you what you're worth, comparably to what men performing equal jobs are being paid. If you're pregnant, that is a big one. From the moment that you notify your employer, through your pregnancy, through your maternity leave, through postpartum, return to work and lactation issues, you may be experiencing differential treatment because employers don't really like pregnancy and maternity leaves and being flexible. You would also may be dealing with unwelcome sexual attention, right? You may be dealing with perimenopause and menopause issues in the workplace, right? And that also, of course, is a sex and age and disability specific problem that you're entitled to complain about. If you're a black or brown or older or neurodiverse, or you have other disability issues that you feel you're being treated differently for, then you must raise these issues formally and complain in writing to your employer, and those complaints are protected under the law. And these aren't Mickey Mouse laws. These are the Civil Rights Act, these federal laws, the Age Discrimination and Employment Act, the Pregnant Workers Fairness Act, the Pregnancy Discrimination Act, there's a number of laws. They all provide for jury trials and all kinds of damages, punitive, attorney's fees, compensatory, pain and suffering. Now, you're not going to trial. 99.9% of you aren't going to trial. Thank goddess. I don't wish that upon you. The point is, when you're suffering with your sucky job because you're a woman, you're black, you're brown, you have a disability, you're older, your ethnicity, your national origin, etc., then you have claims. And when you assert these claims, your employer must, under the relevant federal and state and local laws, investigate your protected discrimination complaint, and they're not allowed to retaliate against you for the complaint. And so that's why we put it in writing, to give them a chance to investigate what you're alleging about your differential treatment or the hostile work environment based on sex, race, color, age, disability, etc. And then they must fix it, launch corrective action. Now, and sometimes they do. They know it's the right thing to do. If it's staring them in the face that you're dealing with microaggressions, differential treatment compared with men or white employees or younger employees or able-bodied employees, etc., they may need to do something about it, right? And now you have this paper trail of protections. And if things go further south as a result, well, then you know now you're unhappy. You know you're working for an employer who doesn't give a damn, right? And at least if you have to leave their employ because they are doubling down on their hostile, discriminatory, and retaliatory treatment, that will put you in a much stronger position to command a severance package if The marriage can't be saved, so to speak, because the company is going to want you to sign a general release of claims and likely pay you severance to ride off into the sunset and get another job. This is really what most people want, even if they don't know it, when they think, I want to go to court, I want to sue them. Yeah, 5 years later, after a public complaint and all kinds of money and resources and emotional investment in the case, and there's no certainty of the vagaries of litigation, what you want is to do this when you're experiencing it in work, to either get it resolved or get out of there with a severance package. But your complaints about discrimination, retaliation, hostile work environment, toxic work environment, bullying, all have to come down to your protected status. Race, sex, color, ethnicity, age, disability, marital status, sexual orientation, gender identity, gender expression, etc. Identify that first, and then put this in writing to your employer. It'll give you all kinds of juice you don't know you have. And of course, it's best to consult with an employee rights lawyer in your jurisdiction, but that's also shouldn't be too hard to find. And many lawyers will work on a contingent fee basis, especially if you've already been fired, but it's still worth it to protect yourself with a complaint to your employer if your workplace is hostile and you're being discriminated against on the basis of some protected status about you or protected activity, such as taking disability leave, maternity leave, family and medical leave for a family member, etc.